Can a woman married under the Hindu Marriage Act claim maintenance if the marriage has been declared void or if it has been annulled because it was a voidable marriage? Before proceeding into this particular topic, we first have to understand that a void marriage is void ab initio. That is, it is null and void right from the beginning because it was in contravention with some of the requirements which are essential to a valid marriage. Whereas a voidable marriage gives the option to any of the parties to the marriage to file a petition under section 12 of the Hindu Marriage Act to get the marriage annulled. Now, void marriages are defined under section 11 of the Hindu Marriage Act. As you can read in section 11, the marriage is said to be void if it contravenes any of the conditions specified in clause 1, 4 and 5 of section 5. Now, as per section 5, if you see clause 1, 4 and 5, it basically says that the parties shouldn't be having a spouse living at the time of the marriage. The next one is that the parties are not within the degrees of prohibited relationship unless the custom or usage governing each of them permits of a marriage between the two. Clause 5 reads, the parties are not sapindas of each other unless the custom or usage governing each of them permits of a marriage between the two. In order to know what a sapinda relationship is or which relationship will fall under the category of degrees of prohibited relationship, you can read the definition clause for the same under section 3 subclause F and subclause G. But we will discuss the same in another video. But here in this video, we'll be talking about the maintenance topic alone. Now, secondly, voidable marriages are defined under section 12. If you see, voidable marriage has 4 different conditions given under clause A, clause B, clause C and clause D. And for the operation of some of the clauses, you have subsection 2 of section 12 where there are certain conditions being given. So if they are all satisfied, then the party can apply and get a decree in that regard to annul the marriage. But if a marriage has been declared void or if a marriage has been annulled under section 12, can the wife claim maintenance thereafter? For this, we can look at the case of Badshah versus Urmila Badshah Godse, which is reported in 2014 1 SCC 188. The equivalent citations being 2014 2 Law Weekly 936, 2013 6 CTC 86 and 2014 Criminal Law Journal 1076. Now, in this particular case, it was held that it was the husband who had suppressed his first and subsisting marriage. That is, the first marriage of the husband hadn't concluded in a divorce or it wasn't declared void or annulled. So it was still existing. It was still subsisting. So since the husband had concealed the fact from the wife and the wife was not aware of the same at the time of the marriage, she cannot be faulted with. So it was held that the wife was entitled to claim maintenance because she was not aware of the husband's first marriage. Here you can establish the doctrine or theory of fault and knowledge. That is, the fault must have been on the husband's side and the wife shouldn't have had knowledge of the same. In such cases, the wife cannot be deprived of her right to maintenance merely because the husband suppressed certain material facts. This was also followed in the recent case of Tarun Chandra Das versus Banjana Kalita by the Guwahati High Court, the case number being criminal petition number 589 of 2021. But on the other hand, can you say that a wife can claim maintenance from her second husband if or if not such husband had knowledge of her subsisting marriage at the time of her second marriage? That is, she already has a husband, but she either informs her second husband of the same or she suppresses the same from the second husband and she marries this person. Can she then claim maintenance from her second husband? This was answered by the Madhya Pradesh High Court in the case of Sangeeta Rathore versus Naresh Rathore. The case number is criminal revision number 4495 of 2018, and also the Tripura High Court in the case of Suparna Saha versus Subhendu Badan. The case number is criminal revision number 28 of 2021. Here it was said that a woman cannot claim maintenance from her second husband if she had married such person when the first marriage was still subsisting. So now you can see that a wife can claim maintenance only if the husband had suppressed the facts and she had no knowledge of the same at the time of her marriage. Even if the marriage is declared void subsequently, she is entitled to maintenance. Whereas if she is the person suppressing the facts, then she cannot claim maintenance from the husband. Now, can this doctrine of fault and knowledge be applied to voidable marriages? For example, if you see under section 12(1)(a), a marriage can be annulled on the ground that the marriage has not been consummated owing to the impotence of the respondent, that is, the impotence of the husband in most cases. What if a marriage has been annulled because the husband concealed the fact that he is impotent and the wife had no knowledge of the same when she married that person? Can she still claim maintenance? In such a situation, the case that we have already discussed, that is the Badshah case from the Supreme Court, was applied by the Kerala High Court in the case of T.K. Surendran vs. P. Najima Bindu, the case number being RPFC number 2 of 2014, where it was said that the fault is not on the wife and the husband is the person who suppressed the fact that he is impotent. Hence, it was held that the wife is entitled to claim maintenance. The same was upheld by the Supreme Court when especially appeal was filed by the husband. Now, from this video, I think you would have understood the concept of fault and knowledge with respect to the wife's right to claim maintenance in void and voidable marriages. Now, this is under the Hindu Marriage Act, and I'm sure the principle will apply uniformly under any other law that is for the time being in force. So if at all you are handling a case or you are yourself involved in such a maintenance dispute, you can definitely use this principle and think if this particular principle applies to your case. If you found this information useful, do subscribe to Lawyer Society and click on the bell icon for more of these informative videos. Comment your thoughts and share this with your legal community so that we are able to reach more of our legal friends and we are able to make more of these interesting videos for you. Thank you. Until next time.